Thank you for joining us today. My name is Tom Van Der Rostein, and I serve as the president of the Louisville Forum. We meet on the second Wednesday of every month at Vincenzo's Restaurant. The Louisville Forum is a nonpartisan public issues group founded in 1984. The Forum hosts debates and discussions of contemporary and sometimes controversial public policy issues that affect the greater Louisville community. Although we may take up issues that have a national interest, we try to highlight the local perspective. For more information on the Louisville Forum, our programs, or to make reservations, please visit our website, louisvilleforum.org. And now for today's topic. Our topic today is home incarceration of violent criminals. Are there alternatives? Excuse me. The Home Incarceration Program, or HIP, is administered by the Louisville Metro Department of Corrections. HIP can be imposed as a sentencing alternative for a criminal conviction, or it can be a condition of a defendant's bond. There are usually over 600 individuals at any time on HIP, and thousands in a year can be placed upon it. Some of these individuals have been convicted of or charged with serious violent crimes. As an example, in the summer of 2017, in the Home Incarceration Program, there were 22 individuals who were on HIP pending murder charges, 15 on sexual assault charges, and other individuals on robbery and assault charges. Some members of our community have questioned whether it's appropriate that individuals who have been charged with or convicted of serious violent crimes should be placed in the Home Incarceration Program. Within the past 2 years, individuals who have been placed in HIP have been charged with murder. In 2017, while on the Home Incarceration Program on other charges, Justin Curry allegedly killed a victim. In January of this year, a defendant was charged with murder, was placed on HIP pending trial, and was allowed to be on the Home Incarceration Program in the home of the victim, and was allowed to be, which was also the scene of the crime. Just last week, 4 juvenile defendants were sentenced to home incarceration and diversion in exchange for their cooperation after being involved in the beating, death, and robbery of a disabled 62-year-old man. On the other hand, home incarceration can be a viable, lower-cost alternative to jail or prison for some individuals, saves our community money, and frees up room for those persons most in need of a correctional setting. It is also an affordable option for those individuals who cannot afford to post a cash or property bond while awaiting trial, and enables the court to monitor that person during the course of the proceedings. And now, before we begin, I would like to introduce our 4-member panel today to discuss this topic. They are Judge A.C. McKay-Chavannes, Jefferson Circuit Court Division 8, Mr. Mark Bolton, Director of Louisville Metro Department of Corrections, Scott West, Deputy Public Advocate for the Kentucky Department of Public Advocacy, and the Honorable Tom Wine, Commonwealth's Attorney for the 30th Judicial District, which is Jefferson County. We will begin comments from each speaker, beginning with Judge Chavannes, followed by questions from the audience, and Judge Chavannes.
Thank you, Tom. Folks, let me start out by telling you, I kind of want to set the context in which I hope the discussion will take place. And it starts with the idea that bond's a big deal because being in jail is a big deal. And being in jail while you're awaiting trial and you've not been convicted of anything is a big deal. And being in jail is expensive. So it's a big deal. However you come at it, left, right, center, it's a big deal. The people who set bonds think it's a big deal too, and I spend a lot of time thinking about bond because I set bonds every day. People who don't set bonds for a living only think about it or have occasion to think about it when somebody who's on bond does something terrible. You read about it or see it, and the first 2 questions in your mind are, and maybe what you're screaming at the television is, how does this happen, and what kind of idiot put this person where they were? Who's the moron who's responsible for this? I have the answer. The second question is not really fair unless you understand the first question, the how did it happen question. And in order to understand that, you got to understand what bond is. So what I'm going to do is hopefully a 3-minute and 50-second primer on bond. And it starts with the idea that if a person gets arrested, they go to jail, but they don't stay in jail. In fact, they have a right not to stay in jail so long as they come back to court and stay out of trouble. What bond is, it's the set of conditions that the court imposes to increase the chances, to maximize the chances that those 2 things are going to happen. Not ensure, not guarantee, but to maximize those chances. The bond is not set according to judicial fiat or whim or caprice. It's set according to law. There are factors that the court must consider in deciding what bond should be for an individual who appears before them. And those conditions, those set of rules, by law, presume, they start with the idea that a person should be released on their own recognizance, on their promise to come back to court and their promise to stay out of trouble. Your word is literally your bond in those circumstances. And that's the presumption unless there's cause to believe that the promise to be good is not good enough. And if that's the case, then the law says that the court should consider imposing a financial bond, a money bond. And the idea of that is to, it's exactly to put your money where your mouth is, but the idea is to back up your promise to have some skin in the game, and the skin is money. Example is, your bond is set at $1,000, so you post $1,000. And so long as you come back to court and as long as you stay out of trouble, when that case is over, you get the money back. And if you don't, you don't. You forfeit that money. The amount of money that is imposed is also set by law, not judicial fiat, not caprice, not whim, but according to law. There are 4 factors, 4 variables, and that's really important because those variables vary very much. But those 4 factors are consistent. Those 4 factors are, how much money do you have? The more money you have, the higher your bond's going to be because the money, in theory, means less to you. If you're willing to walk away from $1 million, then your bond should be higher than $1 million. If $1 million is not going to ensure that you're going to come back to court and you're going to stay out of trouble, if that's not enough to do that, then you should have to post more money. If you don't have any money, you have to be mindful of that too. $1,000 means a lot to somebody who doesn't have $1,000. It might not mean anything to somebody who has $1 million, but it means a lot to somebody who doesn't have $1,000. The second thing you have to think about is the possibility or probability that they're not going to come back. And you look at things like, where do they live? Do they live in Louisville? Do they live in Indiana? Do they live in India? You have to have those kind of, that much information or that kind of information to make that decision. What are their ties to the community? What keeps them coming back to Louisville? And the most important thing you look at is when you're setting a bond is, have they ever failed to appear before? Have they been on bond and not showed up? Have they been on bond and got in trouble before? The third factor is the possibility or probability that they'll get in trouble. And you look at a number of factors to determine that or make that decision too. And you look at their mental health history. You look at whether or not they have drug addiction. You look at whether or not they were on bond when they committed the offense that they're accused of currently. You look at whether they were on probation at the time that they committed the offense that they were accused of committing this time. And you really look at their criminal history, because the more criminal history you have, the theory is the more criminal future you have. It's not precise, it's not math, but it's a pretty good indicator. You can't say to somebody, you know how you've been your whole life, starting tomorrow, be completely different until this case is over. So it's a pretty good indicator of what the future might hold and something you are by law required to take into account. And the last thing you look at by law are the charges. Everyone who comes before a judge when they're having their bond fixed is presumed to be innocent. But the law requires that you look at the nature of the offense and that you set the bond commensurate with the nature of the offense, which means the more serious the offense, the higher your bond is supposed to be. And finally, those 4 factors, those 4 variables combine to decide whether a person should be released on their own recognizance, whether they should post a money bond, how much their bond should be, and what the non-financial conditions are, which include things like the general conditions are, don't violate the law in any respect. No drugs, alcohol, or marijuana, no weapons of any kind under any circumstances. But the more specific things can be things like, you can't drive a car, so I'm going to take your license. You can't leave the country, so I'm going to take your passport. You can only, you have to be in treatment, might be one. And the other one, which we're here to talk about, is HIP. That I'm going to allow you to be out of custody, but you must be monitored by the HIP program, and you must follow the non-financial conditions otherwise imposed. People who can't make their bond, defendants who can't make their bond, their families feel oppressed. They feel like they've been presumed guilty and that everything's already been decided and they're being punished. It feels like punishment. And for victims and their families, when you set a bond that the person can post, it feels like a slap in the face. This guy broke into my house and you let him walk out the door. I get that, but that's also why we don't let defendants or their families or victims or their families set the bond. That's why you have judges, to independently and dispassionately apply those factors in a way that increases the chance the person will stay out of trouble, come back to court, and resolve their charges without incident. So that's the context I hope that we can have this conversation in, and I forgot who's going to go next.
Mr. Bolton. Thank you.
Good afternoon. My name is Mark Bolton. I'm the Director of Metro Corrections, and I Really appreciate the opportunity to be here this afternoon. Before I get rolling, I wanna just hand this out, and you can hand this and circulate it around the group. So I'd like you to see this, and I'll get back to this. Well, I mean, as director of the Louisville Metro Department of Corrections, I want to give you just a little bit of a thumbnail sketch before we jump into the HIP thing. Metro Corrections, you know, you're hearing a lot in the news about overcrowding, about, you know, operating the jail above police headquarters, operating, you know, some of our operating challenges and how overcrowded it is. And it is indeed very overcrowded. We have a capacity of 1,793 jail beds. That's how many fixed beds that we have. We have 925 beds at the main jail complex. That used to be the old MSD building that was reconverted into a jail. There's 925 beds over there. There are about 425 beds above the Hall of Justice. That was built back in the 70s. We have 444 beds over in the hospital district off of Chestnut. That's the Community Corrections Center, which houses minimum security, general population overflow, in work release, 444 beds. That was built back in the 30s. And then when we get way above capacity, when we start trending towards 2,000 inmates plus, and we can see that trend line going up, then we're forced to activate the old jail above police headquarters, and that's 126 beds built back in the 50s, okay? So independent of that, we kind of call that our emergency jail, but independent of that, we have 1,793 beds in the system, okay? Our average daily population for calendar year 2017 was about 2,200 inmates, okay? And you'll see by that picture, we have 40, 45 people that are jammed into a housing unit that's built for 25. I can take 45 or 40 or 45 of you folks here, sitting here this afternoon, and I put you in a space designed for 24. I guarantee you, after a couple hours, you're probably going to start having some problems with one another. And those are really some of the challenges that we face. Just a couple other things. You know, we have a budget. The corrections budget, including health care, is running now just north of $60 million a year to operate. That's what you as taxpayers are paying for the jail system, okay? It's about $26,000 per year to operate one bed, or about $71 per day. That's what it costs. Now, if we were to build a new jail in a central core of Louisville, you know, I just want to throw this out there, it runs anywhere from about $100,000 to $130,000 to build one new bed. So doing the math, and let's just say it's $100,000, 2,000 beds, you're looking at $140 million. So this is a very expensive proposition, and then on top of that, $26,000 a year to operate that one bed. So we're really talking a lot of fiscal types of realities. Final thing that before I jump into the HIP thing, you know, so any given day, 2,200 inmates. Now they're coming to the jail 24/7, 365. Police bring them, I take them. I don't get to choose. So if you're picked up for not showing up for court on a traffic warrant, guess what? You're coming to jail. You can be picked up on an armed robbery or a homicide charge, you're coming to jail. And everything in between, okay? 32,500 times a year, police bring them, I take them. Everybody in this room probably knows somebody that spent the night on 6th and Cedar. The last thing before I jump into the HIP thing, we are running the largest detox facility in the region. We detoxed almost 10,000 people last year of those 32,500 people that came in, we detoxed almost 10,000 of them, okay? The majority of those detoxes were for opioids. So we're running the largest detox center in the region. The other reality that people don't think about, 25% of that 2,200 people that are in custody on any given day have a mental health problem that we've diagnosed, okay, requiring a psychotropic medication. So 25% of that 2,200 that is there on any given day, we've had long enough, or we've known them from before, or we have communication with case managers, friends, or family. This person has a diagnosable mental illness. So we are also the largest mental health facility in the region. And one more thing, we're also the largest restaurant, about 6,000 meals per day. Here to talk about HIP now. You know, the wonderful thing about our country and our forefathers, there's this thing called separation of powers, right? You know, the judicial, the legislative, and the executive branch. Okay, I work for the executive branch. Just like I don't get to choose who comes in the door, corrections does not choose who goes out on home incarceration. We've got criminal justice stakeholders and judges with involvement from prosecutors and public defenders that make that determination. And I'm here to tell you, they're doing a damn good job. Now, 6,100 people were put out on HIP last year, and that period is from June of 2016 to June of 2017, I think, is the data that we looked at. HIP, we don't get to select who goes on. If a person is court-ordered, we are court-ordered to move them, okay? And it's really not a release, it's a movement, because we're still responsible for supervising them. We move them to HIP under supervision. Now, to be on HIP, there are certain requirements that one must have. And number one is you must agree to those conditions of court-ordered supervision. Some of those court orders require mental health counseling. Some of those court orders require job search. Some of those court orders require drug abuse counseling. Some of those court orders allow persons to go to church. Some of those court orders allow people to go to NA and AA, okay? So there are a lot of conditions that a person must abide by when they're court ordered to that program. And additionally, number one, they have to have a place to stay, okay? We don't put people on HIP that are homeless. We don't put people that are in HIP in an area or in a housing situation that is not an acceptable housing situation. I mean, we've had people, we go out and check their home and there's no water, there's no electricity. Well, of course, we're not going to allow a person to live in a place like that. But 6,100 times we were able to put people on home incarceration last year. Now, I conveyed to you all that it's about $70 per day to run a jail bed. Okay, well, to operate at HIP, one participant per day, significantly less than that. Okay, it's about $12 per day. So you've got a significant cost difference. And I'm not trying to do a comparable relative to cost versus public safety, because as the judge said, and I think as you'll hear from Commonwealth Attorney Tom Wine, public safety is job one, right? I mean, that's job one. But we have so many individuals that are in custody in a very crowded situation. It does help the jail when we have programs like HIP that afford the opportunity via court order to put a person back into the community. Now, there's also a lot of upside to that, okay? Returns the person to the community. They can be back out there working. They can be back on the employment rolls, back out there as tax-paying citizens, back out there taking care of their families, back out there, we're not having to pay for health care for a person that's in home incarceration, okay? If we took those 700 or 600 people and we didn't have home incarceration and we were to assume that they were in jail instead, well, guess what? That would mean that we need another 600 or 700 beds at a cost of $100,000 plus per bed. Okay, and now we're talking about $70 today versus $12 a day. So you can see that the fiscal realities really begin to make this a really compelling discussion. Now, I'm confident that our criminal justice stakeholders, our criminal justice community, are doing an excellent job of who they court order onto the program. Now, are there people that have violent charges or could be considered violent charges being court ordered to HIP? Yeah, there are some, but there's not very many. We don't know, I can't tell you what the compelling nature around that court order, but what I can tell you is that that judge sitting on the bench has some pretty good information in front of him or her in which they're making that decision. But when they come out on HIP, and here's one of the things that maybe y'all don't know about, back in 2012, we did not have electronic capability of tracking people that were put out on HIP. We knew when they entered their home and when they left. That's all we knew. We didn't know what was happening in between. So starting in 2012, we brought in GPS technology. And that GPS technology gave us the ability to see where people are, where they're going, where they've been, okay? And that added a very, very high level of public safety enhancement that we didn't have before. Now, if you wanted to look at it, we've got some data that we're just starting to analyze and that we'll report out further here in the near future. But of those 6,100 people that were put out on HIP, by the way, only 11 of them had a homicide-related charge, okay? And that doesn't necessarily mean that they were the trigger person or that they were, that they were actively involved, but they were charged as part of, okay? Only 11 of those 6,100. Of those 11, only one came back on a violation, by the way. Okay? And of those 11, I believe 5 or 6 of them have their charges amended down. Now, one person committing a violent act is probably too many. But as Judge Chavan said, human behavior is a hard thing to gauge. It's a hard thing to predict. But we use the information that's available to us to make good decisions. And once that court order comes in, I have to abide by that court order. And so we supervise people very, very closely using that GPS technology. Now, let me just add before I close. Can HIP be a lot better than it is? Absolutely. Of those 6,100 people that were put out on HIP during that period that we reviewed, 2,100 of them came back. Why? It's not because they did anything wrong. It's not because they committed even an infraction or a dirty drug test. It's because they didn't have a place to live, or they lost their place to live in the community. And those are the types of things that I think we ought to be talking about from both a public health and a criminal justice perspective, because the jail is one of the most expensive beds in town, I'm here to tell you, with very little return on that investment. The ROI over there is not very high. But when we have people that we're bringing back into custody, I mean a huge number, for no other reason than they don't have a place to live, no affordable housing, well, we need to be talking about that too in a very robust fashion. So that's everything I've got, and I'll be happy to answer questions. If any of y'all ever want to come over for a tour, we do tours 24/7, 365. So I appreciate it. So, and if you don't have a warrant, I won't keep you there. Thanks.
And now, Commonwealth's Attorney Tom Wine.
try to watch my time because I get a little passionate about this. Thank you all very much. I was asked to speak, and the topic, of course, was home incarceration for violent offenders or their alternatives. And it's really much bigger than just HIP. Because what we're really talking about is, do we allow people who are charged with criminal offenses, and particularly violent offenses, to be back in the community? And as Mr. Bolton said, and I would say, and I've said repeatedly, as a prosecutor, my primary responsibility is going to be public safety. I have to balance that, though, with, which has also been said, the very core of our criminal justice system, and that is that a person who is accused of a crime is presumed to be innocent. And those are two things that come into conflict quite frequently. And as a judge, for 15 years holding the position that Judge Savannah held, I set a lot of bonds. And I can tell you, I know how those judges feel when they set those bonds. I know how they feel when they make a decision to release somebody on probation after they've actually admitted to an offense and they're now being released. I get that. I know what it's like when you wake up in the morning. I'm old-fashioned. I had a clock radio that go off. I use my cell phone now, but it used to be a clock radio. And the lead story is X, Y, and Z just released on bond commits murder. And you're like, was that one of mine? You wait for the story to come up. You don't hear the name. You get in the morning. The judges all have coffee usually in the morning, and they're all looking. You walk in the door, and they say, it was yours. Now, I didn't know that person I released on bond, who was a bad check writer, was going to go out and kill his mother the next day. But that's a reality because, as said, people are not predictable. But we do have some predictive, if you will, measurements that we try to use and that we encourage. But as I said, all those don't always work as well. There's some things to consider, though. When I said it's not just HIP. Several years ago, here locally, we had a well-known hot dog vendor who was accused of murder. He was a road rage incident, and he shot an individual. Don Hayes was his name. He called the police. He turned himself in. He claimed self-defense. The risk assessment tool said that he was a low risk to reoffend. He had absolutely no prior criminal history. And because he was a low risk to reoffend, he could have been released on his own recognizance. But Judge Delahanty put him out, or set his bond at $10,000 cash. Substantial amount of money. Mr. Hayes posted that $10,000 cash. Now, did the community say, oh, we feel safe about that? He posted $10,000 cash? No. The community was outraged. How could this man who committed a murder and admitted to shooting somebody, that's what everybody's seen, can be released on $10,000 cash? Immediately went to the grand jury. The grand jury indicted. A new bond was set at $50,000 cash. Mr. Hayes posted the $50,000 cash. Was the community satisfied at $50,000 cash? No. It's outrageous. Someone charged with murder is out on the streets. Well, 2 years later, case goes to trial, and Mr. Hayes is acquitted. How could we have given him back 1 day of his time had he been incarcerated that entire time? So whether 10,000, 50,000, 100,000, or HIP, when somebody's released into the community, there's a concern, and I understand that concern, and that's something that our prosecutors have to balance all the time. Whether they make a recommendation to the judge pre-trial or they make a recommendation post-trial, they have to make decisions about whether or not this is safe. And then the judge has to make a decision about whether or not this person is going to be a safe risk to be in the community. Another example is in 2013, a truck driver was arrested and charged with distributing child pornography here in Kentucky. Claimed he was innocent. Judge set his bond at $15,000 cash. He couldn't post it. Judge dropped it down to $25,000 cash plus $22,500 property. Still couldn't post it. 4 times his public defender went back and said, please reduce his bond. They said no. They had a defense expert go through, look at his computer, could find absolutely no evidence of child pornography on his computer. Judge lowered his bail to $25,000 or $2,500 cash. A relative paid it, In 2015, almost 2 years later, the charges were dropped. By that time, he lost his job, he lost his apartment, he missed his son's high school graduation. Now, as pointed out, I think, by Judge Savannah, it has consequences when you're incarcerated. Justice Mitten just signed off on a national program called 3 Days Count. And the premise is to reduce the number of persons who are incarcerated. And when I say 3 days count, this group comes in the PreTrial Justice Institute, on which I serve. This group comes in and they talk about how you can better protect your community and make sure you incarcerate the right people. 3 days, you end up losing your job. You end up losing your ability to pay for your apartment or your mortgage. You end up losing your ability to pay child support. So those are all issues that we have to be faced with. It is a very difficult process, but the alternative, I believe, is that we get away from cash bail. We get away from, and I respectfully disagree with Judge Savannah saying that here are the alternatives. It's either you're released on your own cognizance or you have cash bonds. There are some steps in between, and our rules will recognize that. You can release somebody on non-financial conditions. You can release them into the custody of a third party or individual or an agency. So there are some other ways to do that to make sure that person is being monitored, like HIP. So there are some alternatives to going from ROR, which the law says we have to consider first, to going to the situation where we have cash bail. So HIP is not an evil thing. It is a tool that we use, that judges use and prosecutors use, and it is a valuable tool. We just have to make sure we're putting the right people in. And I know that is not always palatable. I know, again, when you want to rev people up, but when you look at the results, and if you're talking about 11 people out of 6,600, HIP is not a rampant issue. It is not a problem with all sorts of dangerous people being released in our community. And if we get it wrong, we're responsible. If a judge makes a mistake, he or she is going to face that electorate. If a prosecutor makes a mistake in recommending or condoning, he or she is going to face the electorate. That's a reality. And we should face the electorate, and we should be responsible for that. But in the meantime, as indicated, the cost that we are forced to pay, you know, he talks about, Mr. Bolton talks about what's going on here in Jefferson County. When you look nationwide, $14 billion are being spent on incarcerating people pre-trial. People who have not been found guilty, $14 billion. It's the fastest growing segment of our population. I don't remember if you mentioned it or not, but in Jefferson County, between 75 and 80% of the people who are being held in the jail are held pre-trial. They've not been convicted of anything. We don't need to spend $300 million on a new jail. We need to figure out who we need to keep. So we have what I said, the issue is a detention hearing where the persons who are most dangerous, prosecutors go in, present that evidence to the judge, and the judge says, you know what, we're going to hold you without bail. You are a risk to this community. No amount of bond is going to protect the community or guarantee you come back. Is that a radical idea? Heck no. Federal government does it every day. They have detention hearings every day. They have no bail system like we do. New Jersey's doing it now. The District of Columbia has been doing it for 10 years. 88+% of the people come back to court and do not reoffend. Do we want to make a rule for the 12% that's costing us $14 billion a year? Thank you.
And now Mr. Scott West from the Department of Public Advocacy.
Thank you, Louisville Forum, for inviting me here to speak. I'm going to give the criminal defense point of view, and that is that any time that I've heard home incarceration talked about, it's been couched in terms of an alternative to incarceration. But I'm here to tell you that home incarceration should be viewed properly as an alternative to release, because there's a constitutional right to bail. And if you ask the person on the street, well, what is bail? They're going to say, well, that's the amount of money you have to raise to get out of jail. But historically, bail has not equaled money. Bail has equaled release. And so when we say we've had a constitutional right to bail, what we mean is we have a constitutional right to release. And in Kentucky, we have a constitutional right to release except in capital cases. And that's just about every case we have. And this has gone back for a long time. I mean, the Fifth Amendment right to remain silent, the Sixth Amendment right to counsel, those concepts were fully fleshed out in the 1960s. But you can go back 200 years to see that the constitutional right to bail, meaning release, was fully fleshed out in our country. President Andrew Jackson's coming out of a Capitol after attending a funeral of a friend. And Richard Lawrence comes up to him with 2 flintlocks and tries to shoot him. And they misfire. And they said that they had to pull the president off of him at that point, that President Jackson would almost beat him to death if they hadn't. And at the bail hearing, the prosecutor is Francis Scott Key. It's 15 years after he wrote the Star-Spangled Banner, but this is his day job. He's a prosecutor. And bail set at $1,000. And he says, okay, that's good, I agree with that. And then all the president's men gather around Mr. Key and said, you know, he can make $1,000. And if he gets out, he may make another attempt on the president's life. We think $5,000 should be the amount. Now, I want to pause here for a second, and I want you to calculate silently in your head, what do you think the chances, if there were an attempted presidential assassination today, that the person would get out on bail? The chief judge said, if I put bail more than can be made, that's a denial of bail. It's excessive and a violation of the Constitution. So I'm leaving bail at $1,000. Ultimately, Richard Lawrence was acquitted. Reason of insanity, he thought he was the King of England and that Andrew Jackson had taken all of his lands that he was entitled to. But the point is, that is what bail was viewed as. And I thought, wouldn't it be great if Kentucky had that, as a criminal practitioner, wouldn't it be great if Kentucky had that law? They did. In 1950, the Court of Appeals, which was the highest court at that time, Justice Latimer from Jefferson County, he wrote that the issue is reasonableness, and that if you set bail so high as to be prohibitory, the result is a denial of bail, which is guaranteed by the Constitution. That's 1950. And he was the only Republican on the Court of Appeals at that time. And I only bring that up just to make the point that pretrial release, that is not a conservative liberal issue. It's a constitutional issue, and there are people on both sides that support the notion of bail equals release. And then in 1971, said, well, wait a minute. We realize that if people that are getting out are committing crimes, and the Court of Appeals again speaks. In 1971, they say, we're not unmindful that people who are free on bail are out there committing crimes in some cases and bringing attention to the fact that their case remains untried. And we're aware that there's an undercurrent of public dissatisfaction with this state of affairs. But the constitutional guarantees of bail remain unaltered. And any attempt to deny freedom to someone awaiting trial on charges for something he's presumed he did not commit amounts to a punishment prior to conviction. It has always been the fear that if you let somebody out, they may go and commit another crime. But our Constitution says you are presumed innocent until proven guilty, and that presumption has no meaning if you're languishing in jail. So we view home incarceration not as an alternative to incarceration, but an alternative that the judges have to use as an alternative to releasing them outright. And when you look at home incarceration in that light, it becomes a very different thing. It becomes a very valuable tool. You know, Kentucky doesn't have a lot of tools to keep people in jail that they believe are going to be a danger. If it's not a capital case, but you think they're a danger, what are you going to do? If you raise bail so high they can't make it, then you violated a constitutional right. So what home incarceration does, and I agree with Tom Wine, that you take this in consideration with some of the pretrial risk assessments that attempt to tell you whether this person falls into a category of persons who are at risk to recommit another offense. You use that to determine who are the select few that have to be detained without bail because they're too dangerous to release. Who are the next group of few people who we would otherwise release, but we need to put in on home incarceration because they have a right to release, and we can't say they're too dangerous to release. And then everybody else gets out. Money doesn't detain them. Because when you have money detaining people, then what you have is a system of haves and have-nots. And our Constitution ought not to be something that the wealthy can afford and the poor has to watch them get out of jail while they stay in. So when we talk about home incarceration, and someone says, well, I'm against it because they should be in jail, it should be looked at as, well, I'm for it, because otherwise you're going to let them out. We have a lot of work to do to get people who are presumed innocent out of jail. We need to put the back into the presumption of innocence, get people out, and let people know that they have a right to bail and get out of jail. Thanks.
And now we'll take some questions, and I would ask that we keep the answers somewhat as brief as we can, since we're under a little bit of a time constraint. Our first question will be Iris Wilber from the board. Iris?
Great, thank you, and thank you all for being here this afternoon. The first question is to any or all of you. Do persons on HIP get custody credit against a sentence? If so, why?
They do get credit, and that's by statute. The Kentucky legislature has said that any amount of time you spend incarcerated, including home incarceration, you're entitled to credit toward your ultimate sentence. And that goes toward when you're first eligible for for parole if you're sentenced. That's correct. You do get credit.
There's one exception, and I can't remember exactly what it is, that if you have certain level releases, that's an exception to that rule, but the general rule is absolutely, it's day for day. It's like being in jail.
Thank you. Next question, please.
Sure. This is not specified to a specific person. How or will Marsys Law, if passed on the ballot, change the current HIP program?
Any takers?
I'd love to take that. Marsys Law, which of course is the law that it's going to give a constitutional question to the electorate to decide whether or not they want to have a constitutional amendment, which would give victims rights. The phrasing is equal to criminal defendants in the Constitution, and to be present at everything, including a bail hearing. They will have the right to be there. They have, the way the current enabling statute reads, they would be able to have their own counsel. They would be able to ask the Commonwealth Attorney to represent them on the issue of bail. They would have the ability to have someone speak up for them, or they could speak up pro se, but they would have the right to speak up on the issue of bail and argue against release. They absolutely would have a voice. Now, statutorily, they probably do have a voice, and every place I know, Commonwealth attorneys give great credence to what the victims say. This would constitutionalize that, so there would no longer be any, well, we can't do that because the constitutional rights of the defendant are paramount. They would be co-equal, and we have yet to see how that will play out in the courts. I don't believe they could be co-equal. But you will see a rise in the number of persons who will have someone there advocating against pretrial release, or in some cases advocating for release. And very briefly, imagine someone who is being beaten up by their spouse, and they want to drop the charges, and the Commonwealth says, no, we can't do that. You're just doing this because you're afraid of the person. That person will be able to get up and hire an attorney to go in there and say, I want this person released. I want this person to have bail, and the court will hear them. So it's going to work both ways, but victims will have a bigger say when it comes to the bail considerations.
I don't agree in that that's a really interesting discussion that's a really important discussion to have about the impact of that particular law, but it doesn't change anything about bail because it doesn't change anything about the rules, and it doesn't change anything about who sets those rules. So victims oftentimes are present during that discussion, and when we have the discussion in court, what I try to do is explain what bail is so that they don't feel cheated, so they don't feel wronged, they don't feel insulted. And once people understand what it is, I think they have a much easier time understanding why it is what it is. But it's not going to change a thing that I do because it doesn't change anything about the calculus. It doesn't change anything about those variables. It might make it harder politically to say, sorry, this person gets to stay, but that's why we get paid the big bucks. We are independent, neutral, non-political people who look at these things dispassionately. It doesn't mean you don't care. It means that you don't do what you do because of how much you care. You do what you do because it's the law says is what you're supposed to do.
Next question, please.
Okay. I'm going to go ahead and make this more broad, even though it does specify some folks. I have heard that bond for illegal immigrants is often set at higher levels. Is this true?
Yes, because, well, it's a complicated question. The answer is not really, because if they're illegal immigrants, and I don't like that term, the undocumented or whatever, there's a pretty good chance that ICE has a hold on them. So it doesn't matter what you do, because ICE is going to keep them. If you release them on your own recognizance, you lose them. They go to New Orleans or they go to Oklahoma, and you can't get their case resolved. So sometimes we'll actually ask to set a bond, the defense will ask to set a bond that's higher than it would be otherwise in order to keep them away from ICE. But if you do those variables that we were talking about, one of the variables is, what are your ties to the community? What are the chances you're going to come back? And to the extent that you don't have any ties to this community and you don't have any reason to come back, it's going to make your bond higher than it would for somebody who doesn't have those two factors. But it's not because they're illegal immigrants, it's because they're illegal immigrants, they don't score well in those two factors.
And I would just like to ask a follow-up question. Has ICE ever appeared in a bond hearing before in your courtroom?
No. One time they did take a guy and they actually got a writ from the court to let him, they actually got him off the plane to take him back to state court, which was pretty unprecedented. In a murder case, it was a DUI homicide case. And ICE had taken him, they gave him back so that he could be in custody to resolve that case before he was deported. And interestingly, it was at his request. Very interesting guy.
Okay. Next question, please, Dan.
Yeah, this question, a couple of questions here. Probably anybody can comment on this, but Mr. Bolton, you talked about overcrowded and the cost of a new jail. We have elected officials and others who certainly talk about construction projects and for entertainment, for hotels and the like. What's the likelihood of ever getting a new, larger jail that could accommodate everyone it needs to accommodate?
Yeah, I don't, and I appreciate that question. Louisville needs a new jail now. Do we need a bigger jail? I don't think so. The physical plant facilities that we have are antiquated. It lacks, environmental standards. It lacks health and safety standards in terms of HVAC systems and fire suppression systems and the ability to control doors electronically. We have an old jail system here. I mean, part of our jail system, 444 beds, was built back in the 30s. So we need a new jail probably pretty quick. And I hope that comes sometime in my lifetime anyway. Do we need a bigger jail? I really don't think so. When I look and see what other cities are doing and what we're doing here in Louisville in terms of looking at evidence-based practices that are working in other places, that are starting to work here, like bail reform, like housing, like addressing homelessness, like addressing community mental health, like addressing addiction and treatment. I mean, we're seeing some marvelous capacity added in the detox arena with Healing Place and, capital projects and in Centerstone and Our Lady of Peace. I mean, we're seeing some scale out of infrastructure that I think is really going to assist people. I mean, we have people that are in jail that really don't belong there right now, that are brought in on low-level things that are detoxing, but there's no detox capacity to put them, so they come to jail. So I think we have to have that kind of discussion, and then we'll know a little bit more about how big of a jail we really need. My belief is that we don't need any additional capacity. We need to use the capacity that we have in a smarter fashion, and we need to address some of the antiquated facilities that we do have.
There's the part of the line out of the movie, if you build it, they will come. We've got capacity for about 1,800. We're running 22 to 23. If we made it 22, 23, we'll need 25 to 27. Right. When I started as a prosecutor, the statewide penitentiary system, there were 3,000 people in Kentucky's penitentiaries, 1980. There are now 25,000 plus, so an 8-fold increase. The population of Kentucky has not gone up 8-fold. And I don't believe that the population is 8 times more dangerous than it was in 1980. We just default to, let's just put them behind bars. Can't go wrong. They can't possibly hurt anybody if they're behind bars. What we didn't talk about is, on any given days, anywhere between 20 and 50 people are being held in the Jefferson County Jail on a bond of $500 or less. So what we're saying is that that person is unsafe unless they post a $500 bond. Now, at $70 a day or more, maybe, I say this tongue-in-cheek, but maybe the Jefferson County government or metro government ought to just post their bond for them and then get it back when they come back.
We're going to pass the hat around.
They'll get their money back. They'll get their money back. But our population, we have gone from incarcerating people that we were afraid of to incarcerating people we don't like. And when I was a young prosecutor, one of the questions we asked was, how much can your guy post? And that's what we settled on because we assumed they were coming back. Now the question is, how much can't your defendant post or your client post so we know they won't get out? And it's a culture change for all of us.
Next question, please, Dan.
Yeah, this questioner, I think, targets this for everybody. With efforts to end money bail picking up steam across the country, if Kentucky eliminated money bail, how would or how could the HIP program need to be enhanced?
I think, like Mr. West said, you're probably going to need more capacity. I don't have a strong feeling about it either way. You know, I don't make the rules, I just enforce them. And if they come up with a better system, I'll sign off, and I will follow those rules. And what Mr. West's theory is, and it's consistent with some of the others, is you have tiers, basically. The incarceration tier, the home incarceration tier, the everybody else goes home tier. And that's fine, so long as the factors that are being considered by the people who are setting those bonds are factors that should be considered.
Yeah, I want to respond. I think we have to be a little bit careful about that, though. There's this thing called net widening, and I don't want to get to a point where we're putting people on home incarceration just because home incarceration is available. You know, we have a structured program, and there's a thing called technical violations. Well, technical violations don't apply to you and me, but they apply to people that are under supervision. So, technical violation could be, out in an area you're not supposed to be. It could be, having a drink of alcohol. It could be, taking a puff of marijuana. And I don't want to reach a point where we're putting people on home incarceration with all of these structured guidelines that don't need them. So we end up violating them and then bringing them back. So I think we have to be pretty careful about that discussion.
In 2014, New Jersey voters approved an amendment to their constitution authorizing the use of pretrial detention hearings that I spoke about earlier. That went into effect in January of 2017. In the first 6 months under that program, 12.4% of the people arrested were detained without the opportunity for arrest, so almost 88% were released. And 55% of those detention hearings, the judge ruled in favor of the prosecution. So again, judges aren't turning people loose willy-nilly. If the right evidence is there, this person is a danger not to return or to reoffend or to hurt somebody, they're being detained. So it's working in New Jersey.
And may I briefly add to what Tom's saying? The model that they use to determine who's going to go home and who's going to be released is based upon Kentucky's version of the pretrial risk assessment that the John and Laura Arnold Foundation developed using some of our data. So they actually used our instrument that we have today to get those results.
I think we have time for one more brief question.
This question, are judges aware of the overcrowdedness, and do they have an open, regular communication with jail directors?
Big time. We're really lucky in that we have actually an interface. We can call up at any time and know exactly who's in jail, who we put in jail, what their bond is. We have a link directly to the jail interface that is full of information, as much or sometimes more than you can handle. But if you have any concerns, you can dial it up immediately right on your laptop right in front of you on the bench.
We communicate with criminal justice stakeholders on population the data, not only every Monday, but every day if you.
Well, I get my email every Monday.
Yeah, if you want it, and we have, real-time dashboards and all those sorts of things. And we've got I think a lot of really active, robust discussions on, there are a lot of things that drive overcrowding. We hear about the state backup and 25,000 prisoners in the state system. Well, you know what? The state system is so backed up that people that are sentenced to prison for a sentence on a felony, they're staying at Metro Corrections longer because the pipeline is stuck because they're having their own capacity issues. So, this is a really complex discussion, and the more forums like this that we have and the more public education and interaction we're able to have, I think it brings some clarity, but also some call to action that we can't build our way out of this issue.
And Mark, how much does the state pay you for holding their prisoners while they're waiting to transport them?
Yeah, the state pays you as taxpayers, pays Metro $31 a month.
A day,
Yeah.
$31 a day.
A day, $31 a day, I'm sorry, $31 a day, but it's costing us as taxpayers about $71 per day. So not a very good return on that.
Okay, I want to thank each and one of our panelists. This was a very interesting and informative discussion today. On behalf of the entire Louisville Forum, I want to express our appreciation to each one of you with a Louisville Forum mint julep cup.
That's really cool. That's really nice.
Is there julep in it?
I'm not going to tell you what to put in it. You can make that decision yourself. Our next meeting will be held on Wednesday, August 8th at noon at Vincenzo's. The topic will be the legalization of sports betting in Kentucky. Reservations may be made online at louisvilleforum.org or by calling our voicemail at 329-0111. Have a great afternoon, and remember, be nice to people.